Have you ever wondered why some companies can accept deposits only from their members, while others can even accept deposits from the public? Most students memorize Section 73, 74, 75, and 76 separately. And that's exactly where confusion begins. But in today's video, I'm going to explain the entire Chapter 5 in just one flowchart and thereafter in details. Once you understand this diagram, you'll never get confused between Section 73.1, Section 73.2, and Section 76 again. Let's begin. Step 1. Start from the top. First, always start at the top of the flowchart. Ask one simple question. Does the company intend to accept money? If the answer is no, Chapter 5 is irrelevant. If the answer is yes, don't immediately jump to Section 73. Instead, ask the second and most important question. Is this amount actually a deposit under Rule 2(1)(c) of the Company's Acceptance of Deposits Rules 2014? This is the foundation. Because if the amount is not a deposit, Chapter 5 ends here. But if the amount is a deposit, then Section 73 comes into the picture. Step 2. Section 73 applies. Now, many students think Section 73 is only about private companies. That is incorrect. Section 73 applies to every company. So after reaching Section 73, don't ask whether it is a private company or public company first. Instead, remember this rule. Section 73(1) is the general prohibition applicable to all companies. It says, no company can invite, accept, or renew deposits except in the manner provided under Chapter 5. This is the starting point for everyone. Step 3. Type of company. Now move down in the flowchart. Split the companies into two categories, private company and public company. Notice something interesting. Both branches begin with exactly the same provision, Section 73(1). That means both are under the same restriction. This is an important examination point. Step 4. Private company branch. Let's first understand the private company. Ask one question. Is the company accepting deposits only from its members? If the answer is no, it cannot accept public deposits under Chapter 5. End of discussion. If the answer is yes, then move to Section 73(2). This is the exception. Section 73(2) allows a company to accept deposits from its members, but only after complying with prescribed conditions. Look at the compliance box. Members' resolution, circular in form DPT-1, filing with ROC, deposit repayment reserve, deposit trustee wherever applicable, DPT-3, and compliance with the deposit rules. So remember, Section 73(1) prohibits, Section 73(2) permits, subject to conditions. Step 5. Public company branch. Now let's move to the public company. Again, Section 73(1) applies first. Then ask the same question. Is the company accepting deposits only from members? If the answer is yes, Section 73(2) applies exactly like it does for a private company. Same compliances, same conditions. But what if the company wants deposits from the public? Now the flowchart asks another important question. Is it an eligible public company? This single question decides everything. Step 6. Section 76. If the answer is no, the company cannot accept deposits from the public. Simple. If the answer is yes, now Section 76 comes into operation. Notice something very carefully. Section 76 never replaces Section 73. It is an additional provision. An eligible public company must first comply with Section 73 wherever applicable. and then satisfy the additional requirements under Section 76. These include eligibility criteria, credit rating, advertisement, deposit trustee, deposit repayment reserve, and all prescribed rules. This is the biggest conceptual mistake students make. Section 76 is an extension, not an alternative to Section 73. Step 7. Final part of the flowchart. Now both branches finally merge. Whether the deposits are accepted from members or from the public, every company has one common responsibility: repay deposits according to the agreed terms. Now look at the last decision box. Has the company defaulted in repayment? If there is no default, compliance is complete. But if there is a default, Sections 73(4), 74, and 76A become relevant. The consequences include: NCLT can direct repayment, interest becomes payable, and the company and its officers may face penalties or prosecution. Memory trick. Remember this sequence forever. 73(1) to General Rule 73(2) to members' deposits, 76 to public deposits by eligible public companies, 74 to old deposits, 75 to fraud, 76A to punishment. If you remember this sequence, you can solve almost every examination question from Chapter 5. I hope this flowchart has made Chapter 5 crystal clear. If this single diagram helped you understand sections 73 to 76 better than reading 50 pages of the Act, let me know in the comments. Now that we've understood the overall flow of Chapter 5, let's begin with the most important provision, Section 73. If you understand Section 73 properly, almost the entire chapter becomes easy. Section 73(1). The General Rule. Section 73 came into force on 1st April 2014, along with the Companies Act 2013. Now let me ask you one simple question. Can any company in India freely accept deposits from the public? If your answer is no, you're absolutely right. Because Section 73(1) starts with a complete prohibition. It says that no company shall invite, accept, or renew deposits from the public except in the manner provided under Chapter 5. Notice the words no company. Whether it is a private company or a public company, the starting point is the same. The law first says no. Only later does it provide limited exceptions. That's why I always tell my students to remember this one line. Section 73(1) is the general prohibition. It closes the door first, and then Chapter 5 tells us when that door can be opened. An important exception. But wait, does this rule apply to every company? The answer is no. Section 73(1) itself contains an important proviso. It says that this restriction does not apply to banking companies and non-banking financial companies, NBFCs. Why? Because these companies are already regulated by the Reserve Bank of India under a separate legal framework. So there is no need for them to comply with Section 73 for accepting deposits. The central government, after consulting the RBI, can also notify any other category of companies to which this restriction will not apply. Practical example. Let's understand this with an example. Suppose XYZ Bank Limited wants to accept fixed deposits from the public. Can it do so? Yes, because it is a banking company regulated by the RBI. Now consider XYZ Manufacturing Private Limited. Can it publish an advertisement inviting deposits from the general public? Absolutely not. Section 73(1) prohibits it from accepting public deposits. So, what can such a company do? Can it raise deposits at all? Yes, but only through a very limited route. And that route is Section 73(2). Section 73(2), the permitted route. Section 73(2) creates the first exception to the general prohibition. It says that a company may accept deposits not from the public, but only from its own members, subject to prescribed conditions. This is a very important distinction. Please don't confuse members with the public. Members are the shareholders of the company. The public means everyone else. So remember this simple formula. Section 73(1) says no public deposits. Section 73(2) says yes, but only from members and only after complying with the law. Before accepting deposits from members. Even accepting deposits from members is not automatic. The company must first pass a resolution in the general meeting and then comply with every condition prescribed under the Companies Act and the Company's Acceptance of Deposits Rules 2014. These conditions are listed in clauses A to F of Section 73(2). And trust me, these 6 conditions are extremely important from both the examination and practical compliance perspective. In the next slide, we'll decode each condition under Section 73(2) one by one, from Members' Resolution to DPT-1, Deposit Repayment Reserve, Deposit Trustee, DPT-3, and every other compliance requirement. So don't skip the next part, because this is where the real compliance journey begins. Now comes the most important slide of Section 73. In fact, if you're preparing for CS Executive, CS Professional, CA, CMA, or you're working as a company secretary or compliance officer, these conditions are not just examination questions, they're real-life compliances. And here's something interesting. Many students think there are 6 conditions under Section 73(2). Today, you'll discover that one of them no longer exists. Let's begin. Clause A, Circular to Members. The very first condition says, before accepting even a single rupee as a deposit from members, the company must first inform its members. Think about it. If someone is investing money in your company, shouldn't they know the company's financial condition? Of course. That's exactly why Clause A exists. The company has to issue a circular to its members in the prescribed form DPT-1. This is not just an invitation, it is a complete disclosure document. The circular contains important information such as the company's financial position, its credit rating, the total number of existing depositors, the outstanding amount of previous deposits, and other prescribed particulars. Why? Because the law wants every member to make an informed decision, not an emotional one. Remember this: no disclosure, no deposits. That's the purpose of Clause A. Clause B. File with the ROC first. Now here's a question. Can the company prepare DPT-1 today and immediately send it to its members tomorrow? The answer is no. Before the circular reaches the members, it must first reach the Registrar of Companies. Clause B requires the company to file a copy of the circular along with the prescribed statement with the ROC. And there's an important timeline. It must be filed at least 30 days before the date on which the circular is issued to the members. So remember the sequence. Prepare DPT-1, file with ROC, wait for the prescribed timeline, then issue it to members. This is one of the favorite examination questions. Students often reverse this order. Don't make that mistake. Clause C. Deposit Repayment Reserve Account. Now we reach the heart of deposit protection. Imagine a company accepts deposits from hundreds of members. After a few years, those deposits become due for repayment. What if the company says, "We don't have enough money"? To prevent that situation, the Companies Act created something called the Deposit Repayment Reserve Account, or simply the DRR account. Every year, on or before 30th April, the company must deposit at least 20% of the deposits that will mature during the following financial year. This money must be kept in a separate bank account with a scheduled bank. Think of it as a safety locker. The company cannot casually use this money for its day-to-day business. Its primary purpose is to ensure that members receive their money back on time. Let's understand this with an example. Suppose ABC Limited has deposits of 5 crore rupees that will mature during the next financial year. How much must it keep in the Deposit Repayment Reserve account? Very simple. 20% of 5 crore rupees, that is 1 crore rupees. And this amount must be deposited on or before the 30th of April. Examination alert. Now here's a question that appears repeatedly in examinations. Was the requirement always 20%? The answer is no. Earlier, the law required 15% of deposits maturing during the current and next financial year. But the Companies Amendment Act 2017, effective from 5th July 2018, changed the law. Today, the correct legal position is 20% of deposits maturing during the following financial year only. So whenever you see MCQs mentioning 15%, be careful. That was the old law. For exams and practice, always remember the current requirement is 20%. Clause D, the hidden surprise. Now comes the biggest surprise of this slide. If you've opened an old Companies Act book, you'll find something called deposit insurance. But here's the truth. Clause D no longer exists. Yes, the requirement relating to deposit insurance has been completely omitted. The Companies Amendment Act 2017, effective 5th July 2018, removed this condition. So today, companies accepting deposits from members are no longer required to obtain deposit insurance. This is another favorite MCQ. Whenever you see a question asking, "Is deposit insurance mandatory under the current law?" the answer is no. Quick memory trick. Let's revise the first 4 clauses in just one sentence. A means advertise through DPT-1. B means before members file with ROC. C means create the deposit repayment reserve account. D means deleted. That's all you need to remember. We've covered the first 4 conditions. But section 73(2) is still not over. In the next slide, we'll discuss the remaining conditions, including certification of no default, providing security, and other critical compliance requirements that every company secretary must know. So let's continue. Now imagine this situation. A company accepted deposits from members, but when the deposits became due, it failed to repay them. A few years later, the same company again wants to collect fresh deposits. Can it simply start accepting deposits again? The answer is no. But here's the interesting part. The law also gives such a company a second chance. Let's see how. Clause E, Certificate of No Default. Clause E is all about one thing: trust. Before a company accepts fresh deposits from its members, it must certify that it has not committed any default in repaying deposits or paying interest. In simple words, the company must have a clean repayment history. Because think about it, if a company couldn't return money yesterday, why should members trust it with their money today? That's exactly the logic behind Clause E. But what if the company had defaulted? Now comes the most important examination point. Suppose the company had defaulted in the past. Does that mean it can never accept deposits again? Earlier, the answer was yes. A single default permanently closed the door. But the law changed. The Companies Amendment Act 2017 introduced a much more practical approach. Today, a company can re-enter the deposit market but only after satisfying two conditions. Condition number one, it must first make good the default. That means repay the deposits and the interest due. Condition number two, after curing the default, it must wait for 5 years. Only after this 5-year cooling off period can it start accepting fresh deposits again. So remember this formula. Default, repay, wait 5 years, then accept fresh deposits. Practical example. Let's understand this with an example. Suppose PQR Limited defaulted on repayment in 2018. The company cleared all outstanding dues in 2019. Can it accept fresh deposits in 2020? No. Can it accept deposits in 2022? Still no. Only after 5 years from the date the default was cured. That means from 2024 onwards, subject to compliance with all other conditions of Section 73(2). This is a favorite examination question. Students usually calculate 5 years from the date of default. That's incorrect. The 5-year period starts from the date on which the default is made good, not from the date when the default originally occurred. Remember that distinction. Clause F. Security for deposits. Let's move to the final condition. Many students believe every deposit must be secured, but that's not what the law says. Clause F uses two important words. Security if any. That means security is optional, not compulsory. If the company decides to offer security, it must actually create a charge on its assets or property. In other words, don't merely promise security, legally create it. What if no security is provided? Now here's another important compliance point. Suppose the company does not provide any security, or provides only partial security. Can it still accept deposits? Yes, but there's one important condition. The company must clearly describe those deposits as unsecured deposits, and not just once. Every document connected with those deposits, the circular, the form, the advertisement, or any invitation, must prominently mention that they are unsecured deposits. Why? Because the law wants complete transparency. Members should know exactly what level of protection they are getting before investing their money. No hidden facts, no misleading statements. Section 73(3). Honor the promise. Now we've reached the final part of Section 73. This provision is probably the simplest, yet one of the most important. Section 73(3) says, once a company has accepted deposits, it must repay them with interest exactly according to the terms agreed with the members. Think of it as a contract. The company cannot later say, we've changed our mind, or we'll pay whenever funds become available. No, the repayment must strictly follow the agreed terms and conditions. This provision protects the rights of every depositor. Let's understand those in the next slide. Section 73(4) and Section 73(5). What happens if the company doesn't repay deposits? Imagine you've invested your hard-earned money with a company. The deposit matures, the due date arrives, but the company simply refuses to pay. Now the biggest question is, can the company get away with it? Absolutely not. The Companies Act gives every depositor a powerful legal remedy. Let's see how. Section 73(4), the depositor's right. Till now, we have discussed how a company should accept deposits. But what happens after accepting them? Section 73(3) already told us. The company must repay the deposit with interest according to the agreed terms. Now, Section 73(4) answers the next question. What if the company fails to do so? The law says the depositor does not have to wait endlessly. The depositor can directly approach the National Company Law Tribunal or NCLT. This is one of the strongest protections available under Chapter 5. What can the NCLT do? Many students think the tribunal can only order repayment. But that's only part of the story. The powers of the NCLT are much wider. The tribunal may direct the company to repay the deposit, to pay the interest due, to compensate the depositor for any loss or damage suffered because of the delay, and to pass any other order that it considers appropriate in the circumstances. Notice those words, any other order as the tribunal may deem fit. This gives the tribunal broad powers to protect the depositor's interests. Practical example. Let's understand this through an example. Suppose DEF Limited accepted a deposit from Mr. Sharma, who is one of its members. The deposit matures, but the company neither returns the principal amount nor pays the interest. Can Mr. Sharma simply keep sending reminders? He can, but the Companies Act gives him a much stronger remedy. He can file an application before the NCLT under Section 73(4). The tribunal may direct DEF Limited to repay the deposit, to pay the interest, and if Mr. Sharma suffered any financial loss because of the delay, the tribunal can also award compensation. This is why Section 73(4) is often called the depositor's enforcement provision. It converts the company's promise into a legally enforceable obligation. Section 73(5), protecting the deposit repayment reserve. Now let's move to another very important compliance provision. Remember the Deposit Repayment Reserve Account or DRR account, which we discussed in the previous slide? The company sets aside at least 20% of deposits maturing during the following financial year. Now here's the question. Once this money is kept in the DRR account, can the company use it for any other purpose? For example, can it purchase machinery? Can it pay salaries? Can it repay a bank loan? Can it use the money for working capital? The answer to every one of these questions is no. Why? Because Section 73(5) creates a complete restriction. The law clearly says the Deposit Repayment Reserve Account shall not be used for any purpose other than repayment of deposits. This means the account is ring-fenced. Think of it as an emergency fund that has been locked. The company cannot touch this money for business expansion, day-to-day operations, capital expenditure, or any other corporate purpose. Its only purpose is to ensure that depositors receive their money on time. That's why this provision strengthens depositor confidence. That's all for today's revision of Section 73 under the Companies Act 2013. In just a few minutes, we revised the most important exam points: DPT-1, ROC Filing, Deposit Repayment Reserve Account, No Default Certificate, Security of Deposits, and the powers of the NCLT. If you can remember these concepts, you'll be able to answer both theoretical and practical questions with confidence in your CS Executive and CS Professional examinations. If you found this lecture helpful, like the video, share it with your friends, and subscribe to Corporate and Securities Law Compass so you don't miss the upcoming lectures in this Companies Act 2013 masterclass. In the next lecture, we'll begin Rule 3 of the Company's Acceptance of Deposits Rules 2014, Terms and Conditions for Acceptance of Deposits. We'll discuss eligibility, deposit limits, tenure, interest rates, security requirements, and all the important exam-oriented provisions with practical examples. Thank you for watching. I'll see you in the next lecture. Happy learning.